Welcome to the Falmouth Chamber of Commerce.
The Falmouth Chamber is dedicated to working on behalf of our members to make Falmouth a better place to live, work, and conduct business. We are committed to developing the economic, cultural, educational, and civic interests of our community and welcome the support from all organizations to achieve our combined goals. Whether you call Falmouth home, are a summer resident, or a visitor, we hope you take advantage of all that the Chamber has to offer.
Hi, I'm Bob from Crane Appliance. Since 1983, as a family-owned company, our goal has been simple: to give our neighbors of the Cape and Islands a great shopping experience. Rest easy knowing our professional team will listen to your needs and help you pick out the perfect appliances. We'll take care of everything throughout the sale, delivery, and installation process. And we even have our own in-house service department. Crane Appliance, we call the Cape and Islands home.
Carlson Printing for all your printing needs. 508-548-7303 or toll free at 1-800-696-7303. Our email address is carlsonprinting@aol.com. Carlson Printing for all your printing needs.
Hosting services for fctv.org are provided by MegaNet Communications. MegaNet offers a wide array of internet services including Mega Backup Cloud Service, server colocation, T1, fiber, Metro Ethernet, as well as telephone services such as hosted PBX and digital voice. Their number one goal is to keep your communications network up and running and allow you to focus on growing your business. 877-634-2638 or meganet.net.
Select Board meeting of Tuesday, June 21st, 2022. It is now 12 p.m. And I will entertain a motion to go into executive session. And I do hereby declare that not going into executive session to discuss strategy with respect to contract negotiation with non-union personnel, the town manager, to be detrimental.
Second.
All those in favor by roll call?
Patterson, aye.
Scott Price, aye.
Taylor, aye.
Zelinski, aye.
And the board will reconvene in session at 1 o'clock. Okay, I would like to open the session of the Falmouth Select Board. It is now 5 minutes of 1 on June 21st, 2022, and I would like to introduce Attorney Robert Troy.
Good afternoon, Madam Chair. We are here now at concluding the public session, which we opened at 12 noon. We've had an executive session at which time we advised the public that we would be returning to open session, and there are two matters that we need to address in open session before the hearing starts. And the first is the procedure by which the board has determined, or will determine when we have the vote, how it intends to comply with the provisions of the charter in section C5-10E, which is the purpose of the hearing, to state to the public the reasons for the adoption of the resolution to initiate the process of the removal of the town manager. That can be done either of two ways. Either the individual members of the select board can read their reasons, or I have asked the select board members to provide me, as the attorney for the board, with their reasons. The members have not shared them with each other. The members have not deliberated over them. I have had exclusive control of them. I have forwarded them to the chair and requested the chair to take each of the reasons that each board member gave and reduce it to a written document and read it. So your options are each member of the select board who participated in the earlier vote can read their reasons, or you can vote to authorize the chair to read your reasons that have been reduced to writing that you had provided to me. So that's the first order of business.
Does-
Motion that the chair read the statements into the record?
Second.
I have a motion and a second. All those in favor?
Aye.
Aye.
Stay.
Thank you.
The second matter is under the charter. It is required under C5, Section 10F, for the board at a public meeting of the board to announce the date of the hearing at which time. That is the hearing at which it is decided by the board. If it, either way, whether they're going to remove the town manager or not remove the town manager, we need to set a date. The charter requires that it be done within 7 days of the hearing. We're in public session at this point, and I suggest to the board that it's appropriate that the board announce to the public a date for the hearing at which time the board will decide whether or not the town manager should be removed.
And this is to be done at a regularly scheduled meeting? Am I correct? Select board meeting?
Well, this, at a public session, that any public session of the Board of Selectmen that complies with the open meeting law is a regularly scheduled session.
Thank you. Any suggestions?
I'd like to suggest Monday, say June 27th at 6 p.m. before our regularly scheduled meeting.
I will second that, assuming that's a motion.
As a motion.
I have a motion and a second. All those in
Wait,
favor?
can you read the motion? Is the motion to schedule the hearing?
Motion to schedule the hearing for Monday,
Okay.
June
All right.
27th at 6 p.m.
I just want a hearing.
Yep.
I have a motion and a second.
Second.
All those in favor?
Brown eye?
Patterson, aye.
Okay, thank you.
Thank you. I think a motion to adjourn this meeting is in order.
I'll entertain a motion to adjourn.
So moved.
Patterson, second.
Motion and a second. All those in favor?
Aye.
Aye.
For the hearing required under the charter, section 510, where the select board and the town manager shall have the power to call and cross-examine witnesses and to subpoena any and all town records relative to the actions of the Board of Selectmen to initiate the removal of the town manager. I'm David Vieira. I'm the town moderator. Under our town charter, the town moderator, as an independent third party, is to chair this hearing. I want it to be clear that in no way do I have a decision-making power. I'm merely the moderator, the chair, presiding officer of this hearing, to be an independent third party as we hear from the Board of Selectmen for the reasons for termination. We hear from the town manager for the reasons why he may or may not believe those reasons are valid, and then for them to do any cross-examining of witnesses. When we adjourn this meeting, as you heard at the previous select board meeting, there will be a hearing of the board as the decision-making entity to decide whether or not to move forward with the removal of the town manager. Before we start, I had asked back in mid to late May for both parties to let me know who they plan to call for witnesses and for any information they might have relative to procedure. I received a little over a week ago a FedEx packet from the town, from Attorney Troy, telling me their thoughts on procedure and letting me know the witnesses that they intend to call. Mr. Clifford, I never heard back from you after 9:56 a.m. on May the 23rd. So would you please tell me who you intend to call for witnesses today, since you never responded after making a commitment to me to get back to me before this hearing?
Thank you, Mr. Hearing Officer. We sent a subpoena on May 31st to the town. We also had an outstanding public records request. While we received a response to the public records request, we never received a response to the subpoena from the town. As you know, the subpoena is clearly allowed under the charter. One of the things we asked for was what documents, what information would be introduced by the town to serve as a basis for Mr. Suso's termination. We received no response to that. So that was on May 31st. We asked that we get a response by June 4th, June 13th. We got no documents. At this point, we also reached out to Megan English Braga, who is no longer on the board, and asked her to participate as a witness. We received no response back. At this point, reserving all rights depending on what information the town decides to spring on us today, I intend to call Mr. Suso, but we may call other witnesses on the board depending on what we hear.
So did you subpoena Ms. English Braga, or was it just a request to show in person? What was the procedure you used?
We emailed her. We could not, there was no authorization under the charter to subpoena her. We emailed her directly and asked her to attend as a witness. We didn't receive any reply.
Okay. So I received an email a little while ago from Ms. English Braga, and I will just read it for the record. Good morning, Mr. Moderator. I am writing to notify you that I am in receipt of a deficient subpoena in the matter before you this evening regarding Mr. Suso. I received via email a subpoena directing me to appear at the Town Hall in Fairhaven, Massachusetts this evening. At no time was a corrected subpoena received prior to my writing of this email. Therefore, I am under no obligation to appear this evening at Falmouth Town Hall. Megan English Braga, Attorney at Law. I just want that in the record.
If I could, Mr. Moderator, in terms of the issues, so that the public is aware of precisely what the Select Board has done on behalf of the town, the charter, as you know, obviously to the extent it is inconsistent with any other authority unless it contravenes state law, governs these proceedings. And the charter has very specific proceedings. And the only right that both the Select Board and the town manager have with respect to subpoena, as Mr. Clifford has correctly observed, there is no right to subpoena witnesses.
It's the documents.
There is a right only to subpoena town records.
That's correct.
So in order to explain to the public what the Select Board did, town records are equivalent to public records, and town records are kept in accordance with state law, which governs the production of records that belong to the town. And there is, as we know, a records access officer who is in charge of that process. The Select Board decided to use the services of Town Council because the Select Board had confidence in Town Council's ability to look through the computer and identify the records and then make a determination as to whether or not they were public records. And Town Council did just that and has produced, I believe, 148 pages of records that came off the town server that were determined to be public records. In addition to that, Town Council has provided additional documentation today that was requested by Mr. Clifford on behalf of Mr. Suso. And I conclude without deciding that the town has, and the Select Board has complied 100% with the requirements of the charter.
Mr. Clifford, did you receive those documents today that he's referring to?
I received some documents from Attorney O'Keefe, who I think made a good faith and professional effort to comply with the public records request. Part of the subpoena was a specific request for documents that would be introduced today as the basis for Mr. Suso's termination.
Okay.
She has no idea what documents. Attorney Troy represents the town in this matter, which is why the subpoena was sent to Attorney Troy.
Okay.
So we are going to object to any document that was not sent to us that was not part of Mr. Suso's personnel file, which we received, or part of the public records response that we received. Mr. Troy's characterization of what records can and cannot be produced is not consistent with what the charter says. It is not limited to public records. It is any and all town records. And as I've indicated in various correspondence, a termination hearing in this context is akin to the death penalty, all right? Mr. Suso is on trial here for his career and his reputation. The idea that the town doesn't have to produce explicitly what information they intend to use as a basis of his termination is abhorrent. And we can characterize it, and Attorney Troy and I can go back and, make all these, circular legal arguments. He is entitled to know exactly what he's being charged with. And that hasn't happened.
Okay, so let's use that as the segue to the first part of a three-part session. The first, we will have the town give us the reasons that they have used to move forward with the potential removal of the town manager. Then the town manager will have the right to respond personally or through counsel to the reasons stated by the town. And then the select board and the town manager will have the power to call and cross-examine witnesses and use any records that are appropriately in the hands of the parties to use during the cross-examination. Now, you have to realize that I'm not a lawyer, and I'm not a judge, although I'm playing one of those two today on television, but I am a town moderator. And one of the things that I do each and every day for the last 23 years at town meeting is to define scope. And so for me, when I read the charter, when I look at the rights that the town manager has, the obligations that the Board of Selectmen have, today is about looking at the reasons why the town are asking the town manager to resign and then initiating the removal process. So the scope of the hearing will be to discuss those, to bring any new information, to cross-examine witnesses relative to those issues, and then when we have exhausted that, we will adjourn this hearing, and the true tribunal decision-making power of the Board of Selectmen will convene at the meeting next Monday night. So at this point, I'd like to recognize the town, either the chair of the Board of Selectmen or attorney counsel, to state the reasons for the motions to remove the town manager.
Thank you, Mr. Moderator. Prior to doing that, I want to, for the record of this hearing, which is distinct from the public meeting that we had prior to this at 12 p.m. today, I want to provide for the record the process for this. The town suggests that the charter is very clear, and the type of hearing that was outlined by Mr. Clifford is not the process that the town of Falmouth has elected to utilize in its charter. And to the extent that that process is not followed by either party, that the process in the charter was the process which was enacted by the town. And at this hearing, under the section of the charter, Section E, the only burden that the Select Board has is to read aloud the reasons for removal. They have the option to call and cross-examine witnesses, but they're not required to do that. And they have the option to subpoena any town records, and they're not required to do that. So the only requirement in the charter, very clear, at this hearing today, is to read the reasons. The Select Board understands that it is not allowed to deliberate outside of the public hearing process. And so I requested as counsel to the Select Board, each member of the board who participated in the vote, and it's only 4 because there was a change in office for one of the Select Board members, to provide to me and to no one else their reasons for removal. And not for removal, because that's actually somewhat imprecise. It's the reasons in which they voted to initiate the
Process
process of removal under the charter, and to give the town, the public, because this is really my interpretation, this is the public's hearing. This is not Mr. Suso's hearing. This is the public's hearing under the charter, that the public is entitled to hear them. The board has met in public session immediately prior to this hearing and voted to authorize the chair to read their individual statement of the reasons which they wrote, and which none of the other members of the board were a party to or had any knowledge of. So this will be the first time that the select board will hear each other's reasons, and in that context, it will be the first time that the public will hear these reasons. So I would ask to call the chair of the select board to read the reasons.
Okay, so I agree in part and I disagree in part. I believe this is a bifurcation of the reason for the hearing. I believe, one, it is for the public, for public disclosure, to hear the reasons, to hear the response to the reasons. But I also believe it is so that Mr. Suso, the town manager, can clearly state his reasons relative to that in the public forum so that the public has a right to see that. So I agree. I would consider it just a public airing of what is happening, limited in scope. I would say the scope is two-part. One is for the town manager to be able to respond to that and to be able to have his case made, so that if information that was provided today is different, is moving, so to speak, in some way, that between now and the public meeting of the Board of Selectmen, the quote hearing, the next hearing on Monday, there could be a series of actions that could be taken. The board could change its mind based on the information that's presented today. The board could offer a settlement to Mr. Suso, which he might agree to before that point in time, or they might go to the full hearing and then deliberate whether or not to take the vote for the full removal. So there's still many paths forward, but I just don't want to minimize today's forum to say that it's just a public airing of the charges or the reasons, but that it is also for Mr. Suso, town manager, to be able to have his due right to be able to put his information out and try to convince the Board of Selectmen that maybe the reasons are not valid.
And I agree with that. I was just referring to what the board's burden was. I didn't mean to suggest that Mr. Suso did not have rights independent of that under the charter. I agree 100% with your interpretation.
Yeah, Mr. Clifford.
Thank you, Mr. Vieira. I'd like to be heard briefly on the specific point of what is the scope of this hearing. And I'm glad you're experienced as moderator, because the scope is truly important. The scope of this hearing was defined by the resolution that was voted by the Board of Selectmen. And it says that Mr. Suso failed to meet board objectives and failed to conform to town policies. That's it, the resolution. For the board to go back individually or collectively, assuming arguendo that they didn't communicate outside of a meeting, to go back and now flesh it out and now come up with more reasons in addition to what was stated in the resolution is absurd. And the idea that this hearing, that the board's burden is just to say what they think without evidence supporting it, candidly, it reinforces what my communication has been with you and with this board, that this hearing is a sham. They need evidence. Mr. Suso, with 11 good years of service to the town of Falmouth, decades of public service overall, should not be fired on what they think. He should be fired on evidence. And the idea that they don't have to present evidence, again, it's absurd. It's ridiculous.
So without knowing what's going to be presented today, maybe some of that evidence is what we'll hear as we go forward, and we'll make the appropriate decisions along the way.
Thank you.
I'll say it that way. So, Madam Chair.
Thank you, Mr. Vieira. Select Board Member Angele Scott Price. My concerns about the town manager and his performance include the lack of trust from the Falmouth public, which became cumbersome for the Select Board to mediate and manage, the lack of information gathered from town employees' departure, including reasons for leaving and how we might retain employees, and the lack of leadership over initiatives, issues the board has clearly made priorities. I had hoped that my constructive criticism of the town manager would be met with a positive attitude for making change and for moving forward. My criticisms were followed by specific actionable items that the town manager could implement to surmount the issues presented. I participated in the select board meeting on Monday, May 9th with an open mind, hoping that Mr. Suso would review the various feedback provided to him and discuss how he might implement the recommendations and or work with the board moving forward. I was disappointed in the town manager's actions to attack members of the board and to dismiss and minimize the board's recommendations. Members of the public on many occasions told me personal stories of frustration and perceived lack of respect from the town manager. I had not personally experienced this treatment from Mr. Suso until that evening. As a member of the Select Board, I have been elected by the people of Falmouth to represent them. The people of Falmouth have been very clear about their disappointment in the town manager, and rather than taking an opportunity to rectify those concerns and rebuild trust, the town manager chose to present character unbecoming of a town manager. My decision to vote to suspend Mr. Suso came after providing an opportunity for the town manager to reflect on concerns and strive to work with the Select Board to remediate issues and rebuild the public trust. Instead, Mr. Suso broke the remaining threads of trust, which I do not believe the Select Board or the people of Falmouth could have recovered. Select Board Member Sam Patterson. Mr. Suso's performance as town manager has been inadequate to sustain the town's long-term economic vitality, natural environment, property and infrastructure resiliency, and housing affordability. He has been a weak manager of staff, work quality, and productivity. Mr. Suso's oral presentations at town meeting and select board meetings are often halting and unconvincing. He responds defensively and disrespectfully when his positions are questioned. Mr. Suso fails to use effective leadership skills by not participating in open dialogue and deliberations to convince citizens about the best tactical and strategic approaches to address town infrastructure needs or social issues. He resists citizen and select board initiatives rather than allowing them to be decided by a town-wide vote. Mr. Suso fails to use effective planning to address short and long-term threats to the town and to provide a convincing trade-off as the basis for budgeting the use of labor resources, contracted resources, equipment resources, and related finances. Select Board Member Nancy Taylor. My vote to suspend Mr. Suso was grounded in 3 areas: leadership, decision-making, and community relations. Mr. Suso's leadership has been hindered by his unwillingness to take direction from the board, institute action plans for clearly articulated priorities, and lead this community through those processes. He's a passive participant in board meetings, leaving his town assistant and/or town council to answer questions that are directed to him. Mr. Suso relied heavily on both town council and select board to make decisions. As the town leader, I look to Mr. Suso to make sound decisions and present those decisions and recommendations to both the board and the town in a meaningful, well-researched manner. I did not see that happen. The most important concern that led me to vote to suspend the town manager was the growing lack of community confidence in his leadership and the deterioration of the town manager's relationship with community members. I watched as this deterioration took place over the past year, and the volume of complaints I personally received about Mr. Suso has greatly increased. These complaints came from community members and employees. While I spent time defending Mr. Suso, it became clear that the lack of trust from the community and Mr. Suso's response to it negatively impacted the board's ability to move forward. Mr. Suso's response to community members who challenged him was to respond in a condescending and negative manner. I was asked to take on the evaluation process of Mr. Suso and did so in accordance to the contract. I conducted the evaluation such that the criteria were not communicated or deliberated outside of a public session. When the summary was reported out, Mr. Suso responded in an outright public attack of board members with allegations that I found to be baseless and malicious. Select Board Member Doug Brown. These are my reasons for voting to terminate Mr. Suso. First and foremost is his subsequent response to the Select Board's request for Mr. Suso to resign. The attack on members of the Select Board made it very clear to me that Mr. Suso had no interest in resolving the outstanding issues identified in the summary evaluation. It was at that moment I realized that final action must be taken to restore our local government to its functional status. I will address my other concerns in a somewhat chronological order. Mr. Suso historically has failed to act on elements of the Select Board strategic plan. Those failures include neglect of the town beaches, failure to take initiative in development of improvements in services and accessibility. The 2018 strategic plan identified the need for handicap accessible mats for beaches. To date, those mats have not been purchased. The beach buildings are antiquated and in need of significant repair. Beach nourishment, failure to act on a vote of the Select Board to revisit the 2016 beach profile study of Chappaquiddick Beach. The Select Board voted last year to use the $25,000 in beach nourishment allocation and supplement the 2016 study and develop a plan for beach nourishment at Chappaquiddick. To date, no action has been taken. Failure to take initiative on coastal resilience. Coastal resilience action items were identified as early as 2018. The Coastal Resiliency Action Committee submitted their report dated June 2021. It included a number of recommendations. One, for hiring a staff member for administration of coastal resilience and to enhance staffing for grant writing and to integrate findings of the vulnerability assessment. When it was discovered this year that nothing has actually been initiated by Mr. Suso with regard to coastal resilience, the Select Board offered a specific task, which was to hire a consultant to define the logical areas of downtown that would be best preserved with mitigation efforts. To date, no action has followed this vote. I will note several votes on action items on other subject matters have been ignored in the past as well. Online permitting. As a contractor, I found Mr. Suso's refusal to act on this item especially frustrating. I was elected in 2016. At my first strategic planning retreat in 2017, I advocated for the implementation of online permitting. It was left out of the strategic plan in spite of apparent board support. In 2018, it was discussed again and included in the strategic plan as a subgroup of community development. This was, in my view, an attempt to put it off for another year while giving Mr. Suso a way to placate me by telling me it was included in the intent of the spirit of the vote. In 2019, the language was finally changed to improve coordination of planning, permitting, and preservation functions. Once again, elusive wording carefully crafted to avoid the implementation of online permitting. All the while, Mr. Suso privately assured me they were working on the implementation of online permitting. I wasted my whole first year as a Select Board member believing Mr. Suso was taking my helpful suggestions seriously. He would smile and say, "Certainly, Doug, if that's the will of the board." Finally, in 2020, I refused to take Mr. Suso at his word and insisted that specific language be included to identify the goal of implementation of online permitting. As you will note in the 2020 strategic plan, the action item reads, evaluate online permitting options and identify resources required for implementation. This is evidentiary of the fact that the previous discussion of the matter was ignored. In furtherance of this ongoing saga of the failure of the permitting process in Falmouth, Mr. Suso failed to effectively supervise his building commissioner. It was so bad we had hundreds of permit applications sitting for extended periods of time. We ultimately had to call the commissioner before the Select Board to demand action. When the commissioner was informed that we would be seeing him again on a monthly basis for updates, he chose to resign rather than to do his work. Mr. Suso failed to supervise his male department heads and allowed unacceptable behavior to go unpunished. At the same time, female department heads were disciplined severely for any infraction. These infractions could simply be answering questions from the public honestly and clearly. The town manager had a policy of silence from his staff unless statements were authorized by him personally. This unhealthy atmosphere is contrary to the open government model that I hope will replace Mr. Suso after his departure. In closing, I note that Mr. Suso's contract and evaluation period run concurrently starting on October 30. As of October 30 of last year, 3 of his self-assigned 4 short-term goals were not completed. The 4th goal is unknown. We have no evidence of his department head evaluation tool or the timing or results of implementation. He reported it was done in an email, but there's no supporting documentation. By Mr. Suso's own policy, he was responsible for submitting his own self-evaluation in a timely manner. Typically, this is done in November. This allows the Select Board to complete the summary evaluation prior to the end of the year. Mr. Suso finally submitted his self-evaluation later in February. I believe this is a strategic tactic to delay the summary evaluation. I also believe his professional strategy is to put off and delay as much as possible throughout his career in an effort to minimize his workload and maximize his financial compensation. I do not believe Mr. Suso has the town of Falmouth's best interests at heart. I believe he's incapable of taking responsibility for his actions and looks to cast blame on this board to divert attention from his inadequacies. His rude comments to female members of our community are on record, and that alone is cause for dismissal. His repeated statements that he is exempt from the open meeting law are also unacceptable to me personally. I think Mr. Suso has lost all credibility. He has been less than truthful on more than one occasion. I can't work with someone I don't trust.
All set?
Yes, thank you.
All right. So the town manager shall have the right to respond personally or through counsel. Mr. Suso.
I'm going to read a brief statement, then I'm going to address these reasons specifically. The purpose of the hearing today is for the board to consider evidence consistent with the resolution adopted by the Select Board on May 12th. The resolution operates much in the way a court complaint or a civil suit begins. It is simply allegations until the allegations are proven by actual evidence. The process is governed primarily by the town charter, which is the town's constitution, and the 3-year employment agreement that went into effect in November of 2021. That's it. Those are the governing documents. My firm represents several other cities and towns in Massachusetts. I've been on both sides of this type of dispute. One thing that is true everywhere is that, for the most part, the public has no sympathy for town employees. That is particularly true of highly paid employees like Mr. Suso. We have no expectation that the citizens of Falmouth will feel bad for Mr. Suso, regardless of how poorly he's been treated throughout this process. What the citizens of Falmouth should be worried about, however, is how recklessly this Select Board is being with their tax dollars. Mr. Suso is the Chief Executive Officer or the Chief Operating Officer of a $150 million a year business. Over the 11 years he's held that position, he's performed exceptionally well, not in his words, but by the judgment of the people he works for, the Select Board. Along with the team of dedicated professionals, this town actually saw the bond rating increase to AAA, which is exceptionally difficult to do. That means that the bond rating agencies also review the town's finances and the way you operate at the highest possible standard. For citizens that work in the private sector, you're certainly aware that sometimes the board of directors of a corporation, in this case the Select Board, overseeing a large business like this, they want to make a change. Perfectly legitimate thing to do. If we were in the private sector and this employee had a 3-year contract, we would quietly enter into negotiations and we'd try to work out a reasonable severance package. The town is a big business, and negotiated separations are part of doing business. That didn't happen here. After some brief discussions with Mr. Suso in March, then Vice Chair Nancy Taylor progressed right to threatening public termination, saying that she had communicated with at least 2 other members of the board outside of any posted meeting, and that there were 3 votes to fire him. And the board is now mystified and shocked that Mr. Suso, in subsequent meetings where his reputation was being attacked through a completely invalid performance review process, that he was defensive, that he spoke out aggressively. Well, he was threatened, his job was being threatened, his career was being threatened. There's never been a legally posted meeting for this board to have a discussion about the reasons to fire him. To go back retroactively today and manufacture reasons after they already voted the reasons on May 12th, candidly, is something of a joke. There's only two conclusions that we can draw from Ms. Taylor's statements to Mr. Suso on March 18th, that she had 3 votes to fire him. A, that she was bluffing in an effort to intimidate him to accept a lesser severance package, or that she was actually admitting that the board violated the open meeting law and secretly discussed firing him. So if the board was happy enough in 2021 to give Mr. Suso a 3-year contract that began in November of 21, what happened between then and March 22, 4 short months, that would cause this extreme turnaround? The only major issue that happened during that time period between November and March is that a member of the select board, Megan English Braga, had applied for the position of town council with the outspoken support of Nancy Taylor. Despite the support of Ms. Taylor, Ms. Braga didn't get the job, and it is right around that time that everything changed. The timeline is fairly simple. In November 2021, Mr. Suso began a 3-year contract voted unanimously by the Board of Selectmen, Select Board. Also in November, the Select Board met in executive session and again unanimously condemned Mr. Brown for threatening Mr. Suso's job in a September email without any reason or justification. That is public record. There are minutes to reflect that discussion. In January, Mr. Suso rejected Ms. Braga's application for town council. The decision that he made to recommend Attorney O'Keefe was with the assistance and guidance of former town council Frank Duffy and also the HR director. And then in March, at least 3 members of the select board, Mr. Brown, Ms. Taylor, and Ms. Braga, at least those 3 got together and decided that he should be fired. Moving forward with this process, as I noted earlier, the town is bound to follow the town charter and the contract. The town charter is not a menu. We don't get to pick the items we like and ignore the portions that we don't like. Your charter was adopted by the Massachusetts legislature and approved by the governor. It has the full weight and effect of law. In this case, the board has already violated the charter in several ways. They violated the charter by having unlawful meetings in February or March to decide that they were going to fire him, by voting a resolution on May 12th at a hastily called meeting, special meeting, just prior to the town election, to vote a resolution. The charter is very clear. It has to be held at a regular scheduled meeting of the select board. This board and most select boards operate in the same way. They schedule their meetings out for months. There is no reason, if Mr. Suso's performance was so bad and has been so bad over the course of time, as we've heard from the chair, then they certainly could have done this at regular scheduled select board meetings. There was no reason to do it other than the fact that the election was pending. So, again, at a hastily called meeting on May 12th, the week before the election, they vote the resolution to terminate him. The board has also failed to respond to a subpoena that is clearly allowed under the charter, and they have not provided documents that form the basis of their intent to terminate him. Ms. Braga, who was simultaneously Mr. Suso's boss and an applicant for a job he supervised, was invited to be a witness today. She was certainly aware of that, despite any errors that may have appeared in the notice to her, because she notified the hearing officer that she wasn't going to be here. I would certainly like to have asked her a number of questions. If she was applying for the job, I would like to have asked her, why didn't she resign rather than stay Mr. Suso's boss and at the same time try to get him to hire her for a high-paying job with the town? When Mr. Suso, acting on the findings of the screening committee, did not select her, she should have recused herself from voting on his evaluation or voting and just participating in discussions about his contract. You don't need to have a technical understanding of the conflict of interest law to see the obvious conflict. She was his boss, and along with another of his bosses, they were lobbying him to hire her. He didn't hire her, and there were direct ramifications following that. We also believe that Ms. Braga, in fact, expressed a legal opinion that the board was not limited to the 4 objectives that were actually voted in March and were included in the minutes in March. Mr. Brown's comments that they weren't done in October has no legitimacy. They were voted in March when the new contract was signed. The idea was they were going to be done in 6 months. That should have been stated. Mr. Suso responded to a very negative performance review that happened at a prior meeting, and on May 9th he gave a very detailed response where he disagreed. He also stated that he was committed to improving and trying to work with the board and continue to do his job. Following his response, in this document, all of the performance review documents are going in his personnel file. He has a right under Chapter 49, 152C to respond and put something in there. They discussed their concerns at a public meeting. He had every right to respond at a public meeting where he disagreed. There can be no dispute about that. Following his stated disagreements, Ms. English Braga actually said that she was inundated by calls and email complaints about Mr. Suso. So we did a public records request a couple of days after the meeting and asked, where are they? Ms. Braga received or was copied on a grand total of 9 emails in 2021 that could be construed in any way to be critical of Mr. Suso. In 2022, she received 0. So over the course of 17 months, she received a total of 9 emails. Clearly, she has a different understanding of the word inundated than most of us do. Ms. Braga is also a prolific user of text messages, having sent hundreds of texts to Mr. Suso over the course of the last 2-3 years. We asked for text messages between board members. We received none. So apparently we're supposed to believe that Ms. Braga, who was close with the chair, Ms. Taylor, never communicated with her by text over these subjects. I guess we'll have to assume that to be true because we didn't get any of those texts. Mr. Brown had previously threatened Mr. Suso with termination in 2021. And in November of that year, he was admonished by his own board for doing so because it was a violation of the town charter. Mr. Brown actually apologized to Mr. Suso for doing that. And he apologized to the select board for putting them through that process. What's become very clear is that that apology was completely meaningless because he proceeded to rip Mr. Suso in his performance review, essentially saying he didn't do anything right, all evidence to the contrary. The select board is also violating the employment agreement between the town and Mr. Suso in a number of ways. They violated the charter, which under the employment agreement must be followed if the board intends to terminate him. His contract says that. By saying they are in fact going to evaluate and hold Mr. Suso accountable for objectives that were never formally adopted by the select board is also a violation of the employment agreement. His contract says the only thing he can be held accountable for in terms of objectives are those that are officially adopted by the board. There were 4 objectives adopted by the board. 3 members of the select board gave Mr. Suso either meets expectations or exceeds expectations on the specific issue of whether or not he achieved the objectives. The majority of the board found that. Yet we find ourselves here today that saying that he didn't meet expectations or he failed to achieve goals. At that May 9th meeting, Ms. Scott Price asked the question, are we limited to those 4 goals? And Ms. English Braga offered the legal opinion that, no, we're not limited to those 4 goals, which clearly is contradicted by the employment agreement that was signed by the select board and voted by the select board and approved and signed by Mr. Suso. Again, the charter and the employment agreement aren't menus at a restaurant. We don't get to pick the stuff we like and ignore what we don't like. The charter language addressing termination of the town manager can be summed up by saying that the select board needs to state the reasons for termination in a resolution, and then if the town manager requests a hearing on those reasons, he's entitled to that, to find out if those reasons actually justify termination. Attorney Troy and I have had some conversations about what the appropriate legal standard is, the sufficiency of the reasons. We can argue back and forth whether it's cause, just cause, whatever the standard is. What is completely inarguable and not debatable is that the reasons have to be true. And the only thing that is before the select board in this matter is whether the reasons they identified in the May 12th resolution are true. They're saying that Mr. Suso failed to obtain, and I'll read the specific language. They're adopting a resolution to remove the town manager because his failure to implement the goals and carry out the policies of the select board as required by the charter. The goals are part of a formal process. They're included in the minutes of a March 21st, 2021 meeting, the same meeting where they signed a new 3-year contract. Those are it. Ms. Braga's opinion that they can pick and choose new things, and what you heard is a laundry list from all of the 4 select board members that were participated in that vote. They all have different reasons. Unfortunately, none of them were included in the goals and objectives voted by the board. As for not following select board policies, the board has a list of 43 specific policies that are on the town's website. Each of those policies has been discussed, adopted, modified over the course of many years. Not one of these allegations, not one of the laundry list that was read by the chair, alleges that Mr. Suso violated or failed to carry out any of those 43 policies. Again, as lawyers, Attorney Troy and I can argue about the sufficiency of the reasons, but what is inarguable is that it's got to be true, and they're not true. The policies have a very specific definition. The objectives, goals and objectives have a very specific definition. That's it. There are no other things. Pet peeves, pet projects by the select board. Mr. Brown is obviously a contractor, and he's concerned that the permitting process doesn't work as well as he thinks it should. There's a way to address that. Put it on the agenda of a select board meeting and have a discussion about how you're going to fix it. His pet peeve does not constitute justification for termination. Because Mr. Suso wouldn't take pennies on the dollar under threat of termination, the select board moved forward and publicly trashed him in a performance review that is contradicted by their own individual ratings. Mr. Suso had the temerity to publicly challenge this review and try to protect a professional reputation he spent over 40 years to build. The select board called a meeting 3 days later and voted for all practical purposes to terminate him. Mr. Brown, in a press account, actually referred to it as a formality. They need one more vote, clearly indicating that he has no reason to consider anything that is said or produced as part of this hearing. For today's purposes, none of this matters. Members of the board have said privately and publicly, Julian is already fired. It would be, again, it would be naive for me or for Julian to express any widespread public support or sympathy. It doesn't work that way. When the town finds itself facing damages in the hundreds of thousands of dollars or even millions of dollars in this case, I suggest that taxpayers should remember who made these decisions. The town of Falmouth is covered by insurance, and if this case moves to litigation, the insurance company will hire another attorney who will represent the town. I've been involved in many of these cases, again, mostly on the side representing the town. I can say that Falmouth's insurance is almost guaranteed to be the same as what other towns get for insurance, particularly from Maya, the most common carrier. Your insurance company is not going to cover the damages from Mr. Suso's contract. They are not going to cover more than 2 years' worth of salary. The town will be on the hook for that. That's going to be the starting point for settlement discussions. If the select board doesn't want them around, they should make a smart business decision, one that befits their roles as stewards of a $150 million a year business. Addressing the specific reasons, we're objecting to every single reason, every single statement, because the time to have done that would have been a regular scheduled select board meeting when they all could have presented these things and they could have voted a resolution. They could have come to a consensus and said, here are the specific reasons that form the basis to terminate Julian Suso as the town manager. We would have had notice what the reasons are. We would have had an effective chance of rebutting those reasons. What we've heard is, again, this laundry list of specific pet peeves. We asked for all of the emails critical of Mr. Suso because we've heard a couple of comments about public trust. Mr. Brown, at the meeting of May 9th, said it may not be true that there's public dissatisfaction with Mr. Suso, but there's a perception out there. So the idea that the public doesn't trust Mr. Suso, by the admission of then Chair Doug Brown, may not even be true. They've done no research. They have no basis to prove that. We asked for the emails. There were less than 20 emails over the course of a year and a half sent to the select board in total complaining about Mr. Suso. The idea that there's widespread public dissatisfaction, there's no evidence to support that. All of the other issues that were listed really, again, number one, they should have been included in the resolution if they are in fact the basis for their decision to terminate him. Number two, we should have had notice. Number three, there should be evidence to support the allegations. You have none of those things. I would note specifically with the response to the list of reasons for Ms. Scott Price, her performance review, which is part of the record, is mostly fours, that his performance was actually outstanding, and some threes, which means exceeding the standard. Overall, she rated his performance as excellent. Yet, within a week of doing that, she is also voting to terminate him. It's pretty hard to reconcile those two positions. It really is. So, we weren't given, there is no evidence to support these allegations. They are outside the scope of the resolution that was voted by the board on May 12th, because none of them talk about goals and objectives. None of them speak to actual documented board policies. Those are the things that are in the resolution. Those are the only things that should be considered here today. Thank you.
So I do have a copy of the contract with the addendum of the goals and objectives. By way of editorial comment, we need to do a deeper dive because one-word goals are not goals. I don't see an explanation of number one, number two, number three, number four. Online permitting. What's the goal with online permitting, right? That's what this addendum says. So we need a little bit of a deeper dive. If we're going to talk about online permitting and that online permitting wasn't accomplished, what did you want accomplished? Because it literally just says online permitting. Number one, wind turbine disposition. Number three, secure owner's project manager, design architect, and site plan approval for the new Sandwich Road Fire Station. And number four, develop and implement performance evaluation system for major department heads. So those are the current four goals adopted on March 22nd, 2001, verbatim as the addendum to the town manager's contract. So at this point, since both sides have had the opportunity to say what they wanted to say, I'll start with the town. If you want to call any witnesses or you want to have any further discussion about the resolution of failure to implement the goals and carry out the policies of the Board of Selectmen, and I just read what those goals are.
Mr. Moderator, yes, I'd like to respond. First of all, any language in the contract that is inconsistent with the charter is invalid and is ultra vires. And so I direct once again the town charter, which I kind of agree should be considered the Constitution. The town manager is required to meet this goal, and it's in Section A of his powers and duties. The manager shall implement the goals and carry out the policies of the select board. That's all the goals and all the policies of the select board, not anything that is pigeonholed or limited in a contract. That's what the charter says. And all of municipal government is contingent upon the manager doing what the elected executive branch wants to accomplish for the town. And it is very clear that the selectmen identified that in the resolution as the basis for proceeding with the initiation of the process. Now, I believe that the charter needs to be looked at correctly. And if you look at the charter, there is a process.
Let me just ask one question. So under Section 5 of the town manager's contract, under evaluation, it says every year, the date of the appointment, the review and evaluation shall be based on the goals and objectives developed jointly by the board and the town manager.
That's correct, but that's not what the charter says.
Okay.
So that.
So you're telling me that the Board of Selectmen executed a contract in violation of the town charter?
I'm saying to the extent that the contract that the selectmen executed is inconsistent with the charter, it is legally a nullity.
Okay.
That language, a board and a private party cannot agree to terms that are inconsistent with the charter. The charter governs. And the charter is very clear. It is very broad, which is necessary.
So when you're saying goals and objectives in the charter language, you're talking about what other documents, the strategic plan?
It is unlimited. The manager shall implement the goals and carry out the policies of the select board. This is the language the town adopted.
Yeah, so where are the goals of the town selectmen?
The goals are, however, the select board
Yeah, where are
decide.
they? I'm asking to see them or to know where they are.
Well, they might be at every meeting. At every meeting, they may say, well, this is our goal, we want to do this, or a select board says that. That's how government works. It's not all documented.
So day-to-day
Right,
objectives
it's day-to-day
and goals.
administration, and many times, those goals are transmitted between individual members of the board and the town manager and, or the chair. But the point is the manager works for the town, and the selectmen are the executive directors of the town. And how the select board decides to define what the goals and policies are is up to the select board, because the charter gives it absolute discretion. I suggest that that sentence is as broad as possible. And so the question is, did the resolution correctly identify that the reason why the select board was moving in the direction that they are moving in, they were just initiating the process. And keep that in mind. The process is complicated, and it is arduous, and it is a consistent series of steps. So that leads to analysis of the interpretation that you've just heard of the charter's provision as to removal. So Section A is very, very different. That the process of initiating the removal and stating the reasons is very different than the process which takes place after the town manager utilizes Section C and requests a hearing, which is what this hearing is. And the board then schedules a hearing. Now, if you look at the language in Section A, if you want to play lawyer here, which we can do, the charter talks about the proposed removal in Section A. But after the town manager requests this hearing, in Section E, it talks about at any such hearing, that's this hearing, the reasons for the removal shall first be read aloud. That's different. That is a completely different. It doesn't say the reasons for the removal that were identified in Section A, and it doesn't say proposed removal. And so what the select board has done in today's hearing is they have identified what the reasons are. There's nothing in the charter that says the select board has to approve anything. There's no evidentiary burden whatsoever on the select board. As a matter of fact, this hearing is the select board's hearing, and they don't have to prove to themselves that their reasons are correct. No, what this does is it allows Mr. Suso the opportunity, after he hears the reasons that the select board have given, to present witnesses, including himself. His own testimony would be absolutely critical, and his own credibility should be examined to see exactly, so that the town can look at this person and say, is this the person that we want to be the chief administrative officer of the town? We haven't heard that. Instead, we've heard a narrative which is entirely contingent on a legalistic interpretation of the charter that is contradicted by its actual words. These are plain and simple words. So if you look at Section E, which is actually 3 sentences, we know what we have to do today. At such hearing, the reasons for removal shall be read aloud. Done. The town manager shall have the right to respond personally or through counsel. Done. The select board and the town manager shall have the power to call and cross-examine witnesses and to subpoena any and all town records. We are not calling any witnesses. The select board is not. We will reserve the right to cross-examine any witnesses, but this is an opportunity for Mr. Suso, the town manager, to respond. It is not a burden of the select board to prove to themselves that their reasons are valid. As a matter of fact, inherent in the charter is a presumption that the select board, in holding this hearing, is going to look at its reasons. They don't have to prove it, because a reason doesn't have to be proved. A reason is not necessarily empirical. It could be subjective. And the burden is on Mr. Suso to try to persuade the select board so that 3 people say, no, we're going to give you a second chance. And I'm not sure that presentation that I just heard, is persuasive at that point, but I leave that to Mr. Suso. Finally, as to town records, I want to review this once again. We have provided all of the town records that are public records in accordance with the statute. We are required, in interpreting the term town records, to respect the determination by the legislature and the governor as to what are records of the town. The records were taken not from the board members. They weren't asked to give the members. They went right to the town server. And the records were removed, and they were looked at by a legal expert, the town's council, and that legal expert provided all of the town records. So there are no town records. The town was asked to create records, and everybody who knows the public records law knows, it's right in the public records guide, that the public entity is never required to create records. You simply are required to produce any records you have. And they were all given to Mr. Suso, and unfortunately for the claims that are made, the wild, exaggerated claims, there's no smoking gun in the records. And that's kind of says something about what we're talking about here. So finally, in addition to that, there are no other records other than the town records. And I want to state for the record that the select board members were asked to go to their individual accounts and produce any records. 3 of the select board members said there are no records. They did that. They did exactly that. They don't have anything on their personal. This is even assuming personal records are not town records, but even assuming, arguendo, that they could be considered that, there are none. 3 members of the board. The chair, Ms. Taylor, gave all of her records, everything that she had on her personal records, to the town council, and the town council considered that and made determinations as to whether they were pertinent public records to be produced and given to Attorney Clifford. So the town has been...
And some of those were or were not?
I'm sorry?
Some of those were or were not provided?
There was 138 pages provided.
Okay.
130 pages.
Those were all from Ms. Taylor's private email?
No. The 138 pages included
Okay, included.
any. I think Ms. Taylor, she had less than 20. There was, she had de minimis, but they were all given to an independent person, not the Select Board's counsel, not to me. That's why we follow this process. We wanted it to be fair and transparent. We wanted to reassure the public and give the public confidence that it was done. And so the new town council, who frankly has very little to do with this entire process, looked at them through the objective prism of what was a public record and gave them to Mr. Clifford. Now, Mr. Clifford has an appeal, as we all know. He can go to public records. He has a statutory appeal he can exercise if he disagrees with her review. But to say that he did not get the records is not true. He did get the records. He got all town records. So if you look at the criteria in the charter, it is very clear that the Select Board has satisfied each requirement under the charter. And as to the final comment, which I'm responding to, because frankly I don't think it's appropriate, but I'm going to respond because it was made, that Mr. Suso is entitled to hundreds of thousands of dollars for not doing his job as determined by his boss. The answer to that is his contract says exactly what he agreed to take. If the Select Board either asked him to resign or after the hearing process, which will be finished next Monday night, if 3 people decide that he should be removed, he has agreed in contract by signing the document, just like you agree when you have somebody fix your car, what you're going to pay. He has agreed that he's entitled to 4 months compensation. The attack on other members of the board and the creation of spurious issues to try to damage a public official's reputation is reprehensible. But it's all the more reprehensible if that person is the person who's managing the town. Because the person who's managing the town has a responsibility to the town to promote public confidence. And this individual has not done that. And you will see that reflected in the reasons which the Select Board gave today.
A couple of things. The first, in terms of the legal authority, and like, so much for the Select Board not participating in this hearing, whatever. The idea that Select Board members are not limited to the specific goals and objectives that were voted, and I guess I have to give Mr. Troy credit for trying to come up with something creative, because the reasons that they voted on May 12th to form the basis of this termination were nonsense. So now we're going back retroactively and we're going to try to come up with better reasons, ones that we can try to say are arguably true. The idea that he is responsible for individual directives from the Board of Selectmen is contradicted by the Charter, and I'll point out the specific provision. Chapter 3.
When you say individual, you mean from individual members?
Individual members of the board.
Yeah. My interpretation of what I heard was that the directives of the board that come up but aren't written in a policy. That's what I heard. Is that's
well, let me read the provision, and thank you for clarifying that. The board shall not administer the day-to-day operations of the town, but shall direct the town manager to do so. The board shall act only as a collective body, and members shall possess no individual authority. The board shall work through the town manager when dealing with matters involving department heads or other town employees. The board's actions are limited to votes that they take in a legally published meeting. So the idea that there are goals and objectives that are floating out there, maybe kicked around at a meeting, maybe individual directives to outside of meetings, it's nonsense. Of course not. He can't respond to the individual whims of 5 people and try to keep everybody happy. And the proof that that is in fact the case is in the list of concerns that the chair read today. 4 very different accounts of what they think is the basis for this termination. They're not individuals. They act only legally in a board meeting, and if they want Mr. Suso to do something, all they need to do is vote it. It is going to be the policy of this board to deal more effectively with affordable housing. It's a vote, it's a discussion, how do we think we should do it, and you give the town manager directive, this is what we want done. The idea that there are other things floating out there beyond the 4 objectives that were voted, incorporated into his contract, how is he supposed to know what's really important when you have 5 members who have their own different pet peeves or initiatives? The idea that the contract language is null and void because it conflicts with the charter is nonsense. That doesn't really meet what we were told in law school was the purple standard. To stand in front of a judge without turning purple and say, yeah, we signed this contract and we agreed we'd be limited to this, but the charter says no, so we don't really have to do that. It's nonsense. They signed a contract with the guidance and advice of counsel. So the idea that we don't agree that it conflicts with the charter, and number 2, even if there was a conflict, the idea that they're not bound by it is really nonsense.
So, in the spirit of that, termination and severance pay, section 3B, does mention that the town agrees that it shall pay the town manager a lump sum cash payment equal to 4 months' aggregate salary, which amount shall be paid to the town manager on or before the effective date of the termination of his or her employment, provided, however, that in the event the town manager is terminated for gross misconduct in office, the town shall have no obligation to pay the aggregate severance sum provided for in this paragraph.
Correct.
So Mr. Suso, if he leaves, is due legally 4 months' salary.
If he's terminated lawfully,
Yeah.
in accordance with the contract and the charter, that is absolutely true.
Or if he accepts the resignation, which is in the previous.
The argument that's been put forth to us, and Attorney Troy alluded to it, is that the board vote on May 9th to request his resignation operated as a termination. That even though it says request, he had no lawful ability to say no. That vote was in fact a termination. He's gone and he gets 4 months' pay.
So reading that, I saw the information on that, and seeing that, to me, it meant that if there was a violation, then that 4 months piece may not hold up because it violates that portion. So the choosing whether or not to resign was a choice that Mr. Suso had. Should he choose not to resign, then we go to the next stage to see what plays out.
Correct.
And the final stage is he would be due the 4 months' pay, whether he accepted the resignation or it ends up through the termination process, right?
That's
so the
correct.
violation would be, it's more of a cutting, so to speak, of that piece out. He didn't resign, so he doesn't get 4 months for that.
Right.
And then you get to the next stage, which brings us here today. So I'm going to ask Mr. Suso, do you have anything that you'd like to say on your own behalf?
Could we take 5 minutes, sir? Could we take a break?
Take a recess? Sure.
Yes.
And I'll try to figure out why the town code is prohibited from coming up on the Wi-Fi in Town Hall. That's why I was on my phone. I couldn't pull the charter up on the computer. All right, we'll take a 5-minute recess.
Thank you. Mr. Suso, could you identify yourself for the record?
Yes, Julian M. Suso,
And what is your position in the town?
Falmouth Town Manager,
How long have you held that position?
just under 11 years.
Have you done this type of work for other communities?
Yes, I have.
How much service in this line of work do you have?
Well, I've been involved, privileged to be involved in local government for over 45 years, including multiple positions as town manager, city manager, et cetera, in more than one state.
Okay. On May 12th, the Select Board voted a resolution that says, among other things, that you failed to implement their goals. Are you familiar with that?
Yes, I am.
What were the goals of the Select Board for the period in question?
Our jointly adopted goals were wind turbine disposition, online permitting, the implementation process for the Sandwich Road Fire Station, and the development and implementation of the performance evaluations for major department heads.
Did you accomplish those goals?
Yes, all 4 of those have been accomplished.
And what is the relevant period of time by which you had to accomplish those goals?
Well, generally speaking, there's a minimum of 12 months from the time those goals are adopted, but there generally is language that recognizes that some of those may be in process and underway, but it's generally a minimum of 12 months to allow the goals to be significantly attained.
And one of the areas on your performance review was addressed that specific issue, right?
Correct.
And are you aware of how you were rated by members of the board in terms of achieving goals and objectives?
Yes, I am.
Okay. What do you recall about that?
My recollection is that 3 of the 5 members of the board affirmed that I had met or exceeded my goals, or jointly adopted goals.
Okay. The second piece of the resolution that forms the basis for your termination is that you failed to carry out the policies of the Select Board. You're familiar with that in the resolution, right?
I am familiar with it, yes.
Okay. Are you aware of what the Select Board policies are?
Yes.
Okay, and how do you know what they are?
All the voted and adopted select board policies have been placed on the town website and appear there for public information.
As part of preparation for this hearing, did you go through those policies?
I did. I reviewed all 43.
Are you violating any of those policies?
No, I am not.
Have you failed to implement any of those policies?
No, I have not.
Nothing further. Thank you.
Okay. Madam Chair, anything else?
Thank you. Mr. Suso, you're familiar with the requirement, the duty imposed on you by the charter, that you shall implement the goals and carry out the policies of the Select Board, correct?
I'm generally familiar with that charter language.
Well, have I read it correctly? The manager shall implement the goals and carry out the policies of the Select Board.
I can review a copy of the charter and answer your question.
Take a look at mine. I'm underlining the sentence right there.
The manager shall implement the goals and carry out the policies of the select board.
Okay. So does the charter say that the policies of the Select Board as voted and adopted and put on the town website?
The charter says what I just read, sir.
Right, so the charter, the answer to the question is the charter does not say that, does it?
The charter says what I just read, Counselor.
Right. So the charter does not say or limit the policies of the Select Board that you are supposed to be implementing. It's your job. It doesn't narrow them in any way to any process, correct?
I'm not aware of any specific process beyond that, sir.
Well, when you say that you complied or carried out the 43 policies that are on the website, does that meet the requirements of the charter, that you'll implement the goals and carry out the policies of the select board?
In my opinion, yes.
And what's the basis of that opinion?
My personal experience, sir.
So your testimony characterizes the policies of the board differently than the broader terms that are imposed by the charter, correct?
I do not agree with you, Counselor.
It's not a matter of agreeing with me. You said are there only 43 policies that you believe you have to comply with?
I believe I stated there are 43 policies voted and adopted by the board that appear on the town website, and that I have not violated any of those policies.
All right, well,
That's what I stated.
Yeah, what about the other policies? What about policies of the select board? There's a public meeting, the board has said it wants to move in a certain direction, and it is very clear to you as the manager that a majority of the board wants that policy carried out. Are you saying that you do not have to implement that policy? Is that your understanding of your job?
If you would care to give me a copy of what you're referring to so that I can read it, I would be happy to respond.
No,
Individually.
I'm not reading
Are you going to
anything.
give me an opportunity to comment, sir?
No.
Are you going to cut me off?
Yeah.
Mr. Suso, I am asking you a question.
If you don't want me to
Yeah.
respond, I'll
I'm asking you to answer this question, and I'll repeat the question. So if the board at a public meeting adopts, not through a vote, but through consensus, and 3 of the members of the board say, for instance, we want to be more diligent in achieving the goal of affirmative action, do you feel that you are not required in that circumstance to carry out that policy?
You've given me a hypothetical. Kindly give me something that is accurate and actually occurred. I'd like to review it. I'd like it confirmed. I'd like it to be shown in the minutes, and I'll be happy to respond as I've indicated.
Well, no.
Okay, Mr. Troy.
You are launching
We're-
hypotheticals
yeah,
at me.
we're not going to go that far off into the legalese, all right?
All right,
'Cause-
I just
'cause
think it should be
I think
noted
all
that-
3 of us have different interpretations of that type of language, right?
I
And
just
so
would like to
that-
note for the record that the town manager's response, he is elected not to answer a hypothetical question, and quite frankly, it's a completely appropriate question.
Yeah.
It's, Attorney Troy has represented cities and towns for decades, and the idea that a consensus, an idea floated in a meeting is a binding obligation on anyone is nonsense. We have a definition. They stated, they accused Mr. Suso of not following their policies. Their policies are determined. If they wanted to vote another policy, fine. Let me ask Mr. Suso this, maybe this will clarify it. If the Board of Selectmen votes to ask you to do something, are you obligated to do it?
Yes, I am.
So then that leads me back to my question.
Troy.
If there's not a vote, but it's clear to you that the board wants to pursue a specific policy, the board, a majority of the board, are you saying that you are not required to implement that?
How is it you're saying that becomes clear to me, sir?
It's obvious that the witness is asking questions back. He does not intend to respond, and I suggest that this is very telling.
All right,
It's
so
a very simple question.
let's end there with that line, okay? Whether or not a consensus of a non-voted opinion of the board to head in a direction is binding on the town manager is a question that's still a question. So is there anything else related to the resolution for termination, response by the town manager, or we aired those issues relative to the requirement for this hearing, and that the next hearing is the hearing where the tribunal will go through and make a decision based on the information from today as to what action they choose to take?
That's fine. We can proceed to the next hearing.
Okay. Is there anything else that you all would like to present, or Mr. Suso would like to present before we?
No, thank you, Mr. Hearing Officer. We have nothing further to present.
Okay. So,
Mr. Moderator.
so at that point, we'll have The Board of Selectmen had voted at the previous meeting at 6 PM, Monday, I don't have my calendar, the 27th, to convene the hearing required under their next steps. And so we've, I believe, fulfilled the obligations by both parties' consent to adjourn the hearing, and I so adjourn.
Welcome to the Falmouth Chamber of Commerce.
The Falmouth Chamber is dedicated to working on behalf of our members to make Falmouth a better place to live, work, and conduct business. We are committed to developing the economic, cultural, educational, and civic interests of our community and welcome the support from all organizations to achieve our combined goals. Whether you call Falmouth home, are a summer resident, or a visitor, we hope you take advantage of all that the Chamber has to offer.
Hi, I'm Bob from Crane Appliance. Since 1983, as a family-owned company, our goal has been simple: to give our neighbors of the Cape and Islands a great shopping experience. Rest easy knowing our professional team will listen to your needs and help you pick out the perfect appliances. We'll take care of everything throughout the sale, delivery, and installation process. And we even have our own in-house service department. Crane Appliance, we call the Cape and Islands home.
Carlson Printing for all your printing needs. 508-548-7303 or toll free at 1-800-696-7303. Our email address is carlsonprinting@aol.com. Carlson Printing for all your printing needs.
Hosting services for FCTV.org are provided by MegaNet Communications. MegaNet offers a wide array of internet services including Mega Backup Cloud Service, server colocation, T1, fiber, Metro Ethernet, as well as telephone services such as hosted PBX and digital voice. Their number one goal is to keep your communications network up and running and allow you to focus on growing your business. 877-634-2638 or meganet.net.